Good morning, and welcome to Bracewell's Fall ESG webinar. Thank you for taking the time to join us today. And for those who also joined us this past June for our Spring ESG webinar, welcome back. With the increasing focus on ESG issues from the government and regulatory bodies, investors and shareholders, and the public, ESG continues to take an increasing role at the forefront of business considerations. Some companies and boards have appointed ESG officers or committees to ensure that ESG issues are being incorporated into strategic and operational decision-making, as well as receiving the appropriate attention from the leaders of the organization. Keeping with this trend, following the spring webinar, we reached out to our attendees to get some feedback on what topics they would like to know more about. Two of the things our respondents said they wanted to hear more about are the S, or social, and the G, or governance, in the ESG equation. To address that interest, we have 2 segments today and 2 tomorrow that focus on those issues. But of course, the E, or environment, still plays a significant role. For our first segment today, Becky Baker, a partner in Bracewell's Labor and Employment section, will be discussing the intersection of employment laws and ESG. This session will take a look at some scenarios that highlight certain complications that arise when ESG policies collide with employment disputes. As companies take a more public stance with respect to their S aspects of ESG policies, challenging circumstances can present themselves when employees are involved. Becky will walk us through some of the employment law lessons to be learned. For our second segment today, social and governance components of ESG, in an interview moderated by Fernando Rodriguez-Marin, a partner in Bracewell's project finance practice, we will hear from the director responsible for ESG at IDB Invest, Luiz Gabriel Todt Azevedo, who will discuss IDB's policies, not only with respect to risk management, but also, and importantly, maximizing the impact of their investments. Tomorrow, we will start with a segment from our partners, Charles Still and Troy Harder in Bracewell's Corporate and Securities Practice Group. They will present a segment called SEC Disclosure Update and discuss current SEC disclosure rules and practices, as well as expected near-term changes as they apply to ESG-related topics. Finally, for our last segment, Shareholder Activism Through ESG Litigation, David Shargell, Keith Blackman, and Russ Collaro from our litigation practice group will discuss the ways in which shareholders are using litigation to bring attention to ESG matters, with a particular focus on social and governance issues. They will give us some insight into recent cases, such as those against Facebook, alleging a lack of board diversity, and against companies for allegedly promoting a culture that allows sexual harassment to thrive. We hope that you find this webinar interesting and informative. And with that, let's turn to Becky Baker and a look into the intersection of employment laws and ESG.
Thanks, Rachel. I'd like to take the opportunity today to talk a little bit about the intersection of ESG and employment laws. And we'll do a little bit of a ripped from the headlines case study as we walk through the ways employers need to consider how their ESG policies can, in fact, interact with various employment laws. Now, as I believe everybody on this seminar would know, since you've taken an interest in it, ESG is that umbrella term for a broad range of environmental, social, governance factors by which a company stakeholders and really the public in general can assess performance, value, investment in respect of the company. And what we've seen today is that many ESG factors contribute to a company's social license to operate, the responsibilities it has sort of not only to the stakeholders, but to the public at large, and sort of the creation of this holistic value for the company, not just financial, but also in terms of reputation. So, just an example of ESG policy we have from JP Morgan Chase, stating that they believe in and are committed to a culture of respect, equity, and inclusion. And it's focused on strengthening their inclusive environment where employees, customers, and partners feel welcomed and valued in the communities where they do business. So not just within JP Morgan, but out in the community as well. Salesforce takes a pretty strong position where they unequivocally stand against racism, violence, and hate. And they say that they'll continue working to affect systemic change in their communities. Again, sort of focusing not just within the company, but externally out in the community. And so why do we care about this in terms of employment laws? It's the S, that social aspect, that primarily implicates employment law issues. And I would say that probably the most common employment law topic that's addressed in the context of ESG really comes from companies promoting their diversity and inclusion efforts. And so they're asking, how can we increase the ranks of our Black employees, Hispanic employees, Asian employees, female employees, any of those underrepresented groups? How do we do that without running afoul of laws like Title VII that say you can't actually take into account race or sex when hiring or promoting individuals? And that's a topic I've touched on previously, but I want to spend a little bit of time today on a slightly different aspect of the way employment laws come into play with ESG policies. And it's really, with the rise of that public pressure, social media, the fact that employers are publishing these, strong, bold ESG statements about diversity and inclusion, respect, in not just their employment position, but also in the communities. And so, what's the harm in that? And, perhaps nothing. But it does require some risk assessment and some careful responsive action if an employer does actually have to respond to an employee event that implicates its ESG policies. And so at this point, we'll take a deeper dive into the story of Amy Cooper and Franklin Templeton. Now, you probably have to be under a rock to have not heard about this incident. It occurred last May in 2020. And this individual, Amy Cooper, was fired after she called 911 on an African-American man. They were both in a section of Central Park called the Ramble. She had her dog off leash, which was prohibited. And he asked her to put the dog on the leash. They shared some communications. She felt threatened. She ended up calling 911 and stating that an African-American man was threatening her and her dog. Later, that got posted on Facebook, which then gained quite a bit of traction in the media and publicly. And so then we see the employer, Franklin Templeton's response. Their reaction was not just to take internal responsive action, but to go ahead and post this public tweet where they note that they take matters of this nature very seriously. They don't condone racism. And they are investigating the situation and have placed the employee on administrative leave. So it's an interesting choice. They went ahead and decided they needed to get out in front of it, that there was public pressure to respond. And so they very swiftly put out this very public statement. Now, they don't identify the employee by name, but it doesn't take much to determine who that individual is. So I'm not sure that that really plays much into the risk mitigation for Franklin Templeton. They also don't identify as the administrative leave paid or unpaid, which is a choice. A lot of the public response was, she's just getting to sit at home and be paid. What kind of punishment is that? But they didn't know whether it was unpaid or not. So after this statement, the very next day, Franklin Templeton tweets out again. And this time they say that they've completed their internal review, which is pretty quick, 24 hours. And they made the decision to terminate the employee involved. And then they made this very affirmative statement: we do not tolerate racism of any kind at Franklin Templeton. And of course, by doing that, they were insinuating that they believe the behavior at issue was in fact a display of racism by the employee. Now, again, they don't identify the employee by name. They don't say that the employee is a, quote, racist, but they are going out on a pretty public limb there and insinuating that they believed the event involved racism, and for that reason, they terminated the individual's employment. So, what might have been other options? Certainly they could have said that we've completed our investigation. While we don't publicly comment on matters, we can confirm that the individual is no longer employed, and left it there. They didn't necessarily have to sort of announce publicly the reason that they terminated the individual. And that might have, been a little bit of risk mitigation for them when it comes to potential employment claims. So what happened following this termination? Well, Amy Cooper decided to go ahead and file a lawsuit against Franklin Templeton. And I'll get into the exact claims that she raised, because that's a really important point. Oftentimes we see these things playing out in the media and people ask, well, what is the realistic claim that an employee could bring against their company? So we'll spend some time talking about that. But first, I thought it was important to pull a couple of excerpts from the beginning of her complaint. She describes the incident as a confrontation that became international news as a racial flashpoint, characterized as a privileged white female Karen caught on video verbally abusing an African-American male with no possible reason other than the color of his skin. And then in terms of, well, why does Franklin Templeton care about any of that? Well, she says that characterization was actually created and nurtured in part by those tweets and other public statements that Franklin Templeton made. So she's not denying that some of the facts surrounding the incident, those exist. She's not denying that they came into the public view, but she's saying Franklin Templeton stoked the fire. So here's the list of claims that Amy Cooper decided to bring. She brought race discrimination under Section 1981 of the Civil Rights Act, race and sex discrimination in violation of New York State's human rights law, race and gender discrimination under the New York City human rights law, defamation and defamation per se under New York law, intentional infliction of emotional distress under state law, and also negligence under state law. So a garden variety of employment claims. The one that's missing that I find a little bit curious is she did not actually bring a race and or sex discrimination claim under Title VII. And it's possible that the rationale for that was that they did not want to bring an administrative charge. And in order to file a lawsuit under Title VII, you do have to bring that administrative charge first, which then gives an opportunity for investigation and review by the EEOC. So in this case, Section 1981 doesn't require that administrative exhaustion. So it's possible that she and her legal team either missed the filing deadline for that administrative charge, which would have been 300 days after she was terminated, or decided that they didn't want to have to go through that process. And so they wanted to jump straight to a lawsuit. But it is interesting that there's no actual Title VII claim there. In terms of the damages that Ms. Cooper's seeking, she's looking for back pay and bonus, loss of her unvested funds and other benefits, front pay, reinstatement. So she wants her job back, emotional distress damages, attorney's fees, and interest. So let's take a look at the race and gender claims. She alleges that Franklin Templeton's only communication with her occurred on the day of the incident and that she was, quote, palpably distraught and fearful of her safety. So she's trying to say, they said they conducted this whole fulsome internal investigation, but in reality, they caught me off guard. I was very stressed, and they didn't give me an opportunity to really share my side of the story. They go on to say that they also didn't obtain her full 911 calls. So part of this incident was actually recorded by Christian Cooper, the man that she was confronting. And Franklin Templeton relied on what they saw in the video that was posted online, but they did not, ask for all of the 911 transcripts to hear the 911 call center's questions to Amy Cooper while she was on the phone, reactions, things of that nature. So Amy says that's not a legitimate investigation. She also says they didn't attempt to obtain New York City Park Board meeting minutes that predated that incident, which allegedly record that Mr. Cooper had actually been involved in an altercation there before, where he said, yes, it's gotten ugly between birders and unleashed dog walkers. Now, I'm guessing Amy Cooper didn't even know that, around the time of May 2020. I'm guessing that's information that came out later that you wouldn't reasonably expect an employer to know about and go digging around in park board meeting minutes. And so, this does raise the question, well, what should a company do? How should you raise one of these internal investigations if you're trying to enforce something that is tangential to your ESG policy, but also has employment laws at play? And, the standard is not a full complex investigation. An employer certainly doesn't have to go digging into board meeting minutes before they can take an adverse employment action. But it is important that the company behave in a manner that's consistent with past practices. So just because this incident is very public and there's pressure to act swiftly, it would be important for the employer to sit down and say, hey, how have we handled our investigations in the past? How long have we taken? How many folks do we try to interview? What level of information have we needed before taking adverse employment action? And are we being consistent here? Simply because you don't want it to be that, in the other case of the investigation, it was a male and that you did this very thorough investigation before acting, such that your then female plaintiff can say, had I been male, I would have gotten a better shot at a thorough investigation. So she's saying, Amy Cooper's saying, you would have performed a proper investigation if I was a different race or if I was male. And she doesn't even give an alleged comparator for her claim that had she not been white, you would have investigated more. So that's going to be a tough claim to advance. She does give a comparator, an alleged comparator, with respect to her sex or gender discrimination claim. And that comparator is an individual who had joined Franklin Resources Board of Directors. And he had a prior conviction for assaulting his wife. This was back in 2002, and he was brought on board in 2013. And so, yes, you could make some arguments there that, you let the male employee engage in bad behavior, but not the female employee. But if that's what you've got in your complaint, it seems like you're reaching. You're reaching all the way back to 2013, and you're reaching back to an incident that really is quite different than the situation at hand. And so, that's exactly what Franklin Templeton responded to. They filed a motion to dismiss her claims. And, they pointed to the Supreme Court's position that in order to bring a claim for discrimination under 1981, which is that race discrimination claim, you have to at least plead that but for your race, you wouldn't have suffered the loss of your job. Amy Cooper has not provided any evidence to demonstrate that it was because she was white that she was terminated. And she doesn't provide a single, non-white comparator to establish that claim. And then again, as to the sex discrimination, it's the same issue. She doesn't have a great set of comparators to demonstrate that had she been a male, they would have investigated the incident differently or responded to the incident differently. So next, let's talk about her defamation claims. I think that those are really the claims that have some real teeth here. These are the types of claims that employers need to be aware of, particularly in these public environments. If the company puts out these statements that they don't condone racism, that they are seeking to actively increase diversity and inclusion in their communities. And then if something like the Amy Cooper incident happens publicly, naturally there is a public response to that. And really, even if they don't have, public ESG statements, what we've seen recently with, the availability of everybody has a camera on them and can record things, then post it, and it's easily accessible. There is that reaction by employers who want to say, well, we want to tell the public we agree with them or we don't agree with them, and this is why. And we want to get into the details of it, which is really a departure from what has been the classic position with respect to employees. Typically an employer would rely on a statement to the effect of, we don't comment on our relationship with employees. We don't comment on the reasons why somebody is no longer employed. And the reason it's always been that way is defamation claims. So, with respect to Franklin Templeton, they decided to immediately post the tweet about placing her on administrative leave and then follow up with the tweet, less than 24 hours later, letting the world know that they fired her. And not only do they fire her, but they insinuated that her behavior was a display of racism. And after the tweets, the president of Franklin Templeton, Jenny Johnson, she actually took two more opportunities to share information about Amy Cooper with the public. She did an interview with Bloomberg and an interview with Fortune magazine, and gave very similar statements. Simply that Franklin Templeton doesn't condone racism, that they found the behavior displayed by their former employee as inappropriate and in conflict with their policies, and really decided to address the topic as opposed to sort of going that more quiet route of, we don't discuss situations with our employees, but as that individual is no longer employed with Franklin Templeton. That might have gone a long way with the public in terms of, look, we're standing up for our policies and what we say, but we're not going to say anything that puts us at legal risk from the respect of a defamation claim. So Amy Cooper went into a little bit of detail in saying that, it wasn't just that Franklin Templeton commented on the situation. It's that they made it look to the world as though they had completed this thorough, exhaustive investigation and came across completely undisputed facts and acted on it. And Amy Cooper takes issue with that, saying, no, you did a cursory review. You spoke to me when I was in distress. You looked at the video. That wasn't a thorough investigation. You don't have undisputed facts. And by saying this, you're putting it out to the world as if it is true and factual, and it harms my reputation. Again, during the Fortune magazine, the president, Jenny Johnson, announced that Franklin Templeton espouses zero tolerance for racism. So again, sort of doubling down on that idea that, they do believe that her behavior was racism, and sort of identifying this former employee as a, quote, racist. So Franklin Templeton's response to that is that, first of all, everybody was aware of the story. Our tweets are not what caused Amy Cooper harm. It was her own behavior, and it was her own behavior that was captured on video, put on Facebook, and circulated throughout the world. And we were actually dragged into that as her employer. So it's, sort of her fault that we had to comment on it on the first place. Technically speaking, the defamation claims they allege should fail because they are expressions of opinion, and because the complaint fails to allege that they made statements with any sort of actual malice, that they were just describing the incident, that they investigated it, and that the person is not employed with them anymore, and that they don't support racism. And it is true that courts in New York and in other jurisdictions have consistently held that terms like racist are considered an opinion, that is not a fact, and it's not a statement of fact, and that as an employer, you're permitted to share an opinion that you believed the behavior that she displayed is racist. Her next claim was intentional infliction of emotional distress. And this was a little bit interesting. Again, she alleges that these public statements that they had conducted that full investigation and that they had concluded indisputably that she was a racist, when all along, allegedly, Franklin Templeton really didn't conduct a thorough investigation. They, alleged that was extreme and outrageous behavior, done with a disregard of a substantial likelihood that it would cause Amy Cooper emotional distress. And she did, in fact, suffer severe emotional distress. Now, emotional distress, intentional infliction of emotional distress, is one of those claims where the plaintiff has to demonstrate that the employer engaged in extreme and outrageous behavior. It's really a claim that's reserved only where the conduct has been so outrageous in character and so extreme in degree as to go past all possible bounds of decency. It's really supposed to be something extreme that everybody would recognize as being outrageous. And so, of course, Franklin Templeton responds, no, she doesn't come close to pleading in her complaint that our behavior was extreme and outrageous. All we did was we were getting massive amount of public statements to comment on it, and we pretty succinctly commented on it. And we did, in fact, believe that we did a thorough investigation. And we did, in fact, believe that the behavior didn't comport with our policies. And so we did, in fact, terminate that employee. And, how is that really extreme and outrageous? They also allege that this IIED claim, as we call it, is based on the same conduct as her defamation claim. So she can't sort of recast the facts to try to plead another claim as well. And then lastly, we have the negligence claim. To assert a negligence claim, she has to allege that employer owed her a duty not to harm her. And she says that they breached that duty because they had a telephone system that provided her personal cell phone number, and the public could access that personal cell phone number. And reportedly, many people did access the number and then call her and make threatening and harassing statements during those phone calls. And so that's a really interesting one. It is a good reminder, if you do have a situation that's out in the public like this, should you double check what sorts of access you give the public to the individual to make sure that, regardless of whether or not some type of claim like this could survive, just to put it at bay before it even comes into being. Now, the good thing about a negligence claim for employers is most employers have workers' compensation insurance, and most state workers' compensation laws provide that such workers' compensation benefits are the sole remedy for some type of harm of this nature. So it is important in Texas. You can be a non-subscriber as an employer. So not every employer in Texas has workers' compensation coverage. And that's something to think about, is just that a negligence claim of this type would be able to be pursued outside of the workers' compensation framework. So that's really Amy Cooper's story. We'll wait to see exactly how it plays out in the courts. I think that, as I said before, probably the riskiest claim here is the defamation claim. And even then, I think that Franklin Templeton is likely to succeed. Of course, this is just my opinion. I have no idea, and we'll have to wait and see. But what it does do is it gives employers, a reminder that before you take an adverse employment action and before you make a public comment on it, think about ways in which you can mitigate the risk. And is the risk of sort of the public condemnation of an employer's behavior if they don't speak out on exactly why they terminated the employee greater than the risk associated with, claims, discrimination claims, defamation claims, and things of that nature? And it's not just race issues. It's not just females asserting sex discrimination claim issues. There's another example, again, from last summer. This individual, Jeremy Rainick, he filed a state court lawsuit. So Amy Cooper's was a federal court lawsuit. Rainick's is a New York State Supreme Court lawsuit against NBC Sports for wrongful termination. And he's alleging that the network discriminated against him because he was a straight man, and they terminated his employment because of his off-color remarks that he made on a podcast. So a similar situation in terms of being out in the public. You're making statements on a podcast, which can be accessed by, anyone. So it's not, I guess it's not quite the same as being caught off guard and videoed, but again, it's just a public comment off duty. You're not doing your job. But the employer felt like it could take action for it. And he alleges he was discriminated against based on his sexual orientation and gender. He also made some allegations that, were more contractual in nature. They fired him without cause when they had to. And then he also does try to raise a retaliation type claim that he, expressed support of former President Trump and that he was terminated for that reason. And, really what he was basing his claims on, he went on this podcast. He made jokes and comments that he was having inappropriate sexual relations with his coworker at NBC Sports. He alleged that he was joking, but that was the basis for his termination. And he pointed to another NBC sports reporter, Johnny Weir, who is known for very colorful commentary at the Olympics, I think primarily figure skating, but also in other arenas. And he's very openly gay. And Rainick's claims were that he had heard and he had been told that Johnny Weir could engage in that type of off-color behavior or, pushing the boundaries of what may be considered appropriate sexually or otherwise because he's a gay male. And me, as a straight white male, I'm not allowed to make those types of comments. Well, the judge didn't buy it at all, the judge in New York. He said a comparison of two incidents that were presented did not even come close, that Johnny Weir was making jokes about his colleague and that it was very clearly a satirical skit, whereas Mr. Rainick's behavior was on a podcast. It wasn't pre-planned. It had the very real effect of harassing his colleague who wasn't in on the, skit like it was with Johnny Weir. And so he said, simply put, Johnny Weir never joked about having sex with a coworker, and Rainick did. So these were not comparable incidents. Another incident that just took place, and there's no actual legal action yet, because I think this really just occurred about 2 weeks ago, and you may have seen it again on social media, is an individual named Logan Dorn. He actually worked for a Christian-based construction company, Mighty Hand Construction. And he was on a beach and he saw a group of women who were wearing bathing suits, bikinis, and he felt based on his strong Christian convictions that they were dressed inappropriately. He approached them. I think you could argue whether or not it was aggressive or not. He wasn't yelling, but he certainly sort of invaded their space and made very derogatory comments to the effect that they were engaging in pornography by wearing their bikinis on the beach. So once again, we get a public statement from this employer. And they say he was accused of harassing, so sort of a very specific term that could have a negative impact on the individual in the future. Says they began investigating this morning and again had the immediate termination. They don't condone his behavior, nor do his actions reflect their values as a company. And they focus on respect and acceptance there. And something that's interesting is they have a code of conduct that goes into great detail with respect to respect and integrity. One of the top points is they will treat all people with kindness and decency. And so, that's a good reminder for employers. If you do want to take action based on off-duty conduct of employees, what do your policies actually look like? Do you have policies that can support that? And so they're maybe not specific ESG policies. They're more specific code of conduct type policies. And I think that might help Mighty Hand in the event that Mr. Dorn decides to try to bring some type of religious-based discrimination claim. I also think the fact that the company is a religious-based organization might make that difficult for him to, once again, he has to provide that comparator. Why was I targeted or treated differently based on my religious beliefs? And it seems like that's probably going to be a difficult thing for him to advance given their faith-based statements. But another aspect of Mighty Hand's post, theirs was on Facebook, not Twitter, is the fact that they identified the employee by name. Again, that's, there's a benefit to that in terms of responding to the public. There's a risk to it in terms of a defamation type claim. And then the last example I wanted to give relates to an individual that used to work for Todt Insurance. He was in a Costco and he engaged in a very aggressive conversation with an individual who had asked that he please put on a mask. Again, this is different from the Logan Dorn situation where I mentioned it wasn't really all that aggressive. It was certainly disrespectful what he did, but it wasn't necessarily aggressive. This individual engaged in sort of very threatening, aggressive behavior. And Todt focused in on that as their reason for termination. They said that the behavior was in direct conflict with their company values. Again, you see no particular employee is named there. And it's a fairly vague statement, just simply being in conflict with their values. And so that might, again, be helpful in trying to defend against any claims that this individual might bring. So in terms of sort of proactive steps, what would we advise? If you've got your ESG policies, you've got your ESG statements, and they say you don't tolerate things like racism, they say you want to promote diversity and inclusion and respect in your community, how do you respond if you have an off-duty conduct situation that seems to be out of step with those policies? And of course, it's really about thinking before reacting. The first thing to do is see if the activity violates any company policy, any policy that applies to your employees. The more specific you can be, the better. The more you can address that specifically with the employee, perhaps the less likely the employee would take action. And of course, as you look at those policies, you want to make sure that they are in fact legally compliant, that they're consistently enforced, and that your reaction is consistent with prior behavior. And I think that's a place where we see employers get tripped up. Sometimes if something's not out in the public, you just hear about it, it's dealt with sort of internally, there may be less pressure to take swift action, very adverse action, or public action. And you really want to consider that, moving forward. Well, are we treating this individual, the white female, as consistently as we have, the black male? If there is no policy violation, a clear policy violation, which sometimes there isn't in these situations, sometimes it's just that the behavior is out of line in what's in the company's best interest. So you kind of look, is there some type of legitimate business reason to take that adverse employment action? It doesn't have to be in writing in a policy. What are you going to articulate as the legitimate business reason if you're challenged in a court? You do want to ensure that you conducted a thorough investigation, always talking to the individual at issue, always giving them an opportunity to share their side of the story, asking them if they know of, helpful information, more thorough information. Had Franklin Templeton asked that question of Amy Cooper, I bet she would not have brought up the New York City board minutes. And so then it really would have undercut her argument that they should have investigated something like that. So it really is about, stepping back, seeing what information is available, acting on that information as presented, and making sure that you engage with the subject to see, is there anything else we're missing that you think we need to know? And then you have to weigh the risk of litigation versus the risk of your ESG and other policies being violated and coming under public scrutiny. For some companies, getting out there and tweeting about the issue and being specific about their actions is, worth the risk of some type of defamation claim because they feel like that's, a very important part of these policies that they have. For other employers, it may be that they're willing to say that the individual is no longer associated with us, but beyond that, we don't talk about specific employment issues. And then the last thing to remember is because these situations often involve off-duty conduct, you do want to do a review of, are there any applicable laws that would otherwise protect that conduct? Just a list of a few states that have off-duty conduct laws that say that, essentially an employer can't take an adverse employment action for somebody engaging in lawful conduct outside of work. In the case of Amy Cooper, she actually did have some criminal charges brought against her. But typically these off-duty conduct laws are focused more on, engaging in things like political speech or, organizing efforts, things of that nature. So it shouldn't be too concerning in taking adverse action based on your policies and the off-duty conduct, but it is something that you want to double check. And you also want to double check, is this a National Labor Relations Act covered issue? A lot of times people see NLRA and they think we don't have unions, so I can ignore that. And that's not actually the case. The NLRA does protect employees who are not union employees, and they are permitted to engage in concerted activities with others regarding the terms and conditions of their employment. So every now and then we see this type of behavior that's off duty, certainly not Amy Cooper's case, but other types of behavior that an employee sort of shoehorns into. I was simply exercising my NLRA protected rights to engage in protected activity, that this is somehow related to my job, the terms and conditions of my employment. And so you can't terminate me because I posted something on Facebook or I did something out in the community. I attended a rally or something of that nature. Again, I think those types of cases are certainly going to be more rare, but as you're checking off the boxes of how do we best protect ourselves in responding to these incidents, that is one that you're going to want to take a look at as well. So that brings us to the end of our conversation here today. Again, it's one of those fast moving topics that social media has really driven employers to shift their behavior in ways that we haven't seen, to be more public about their employee relationships and their policies that cover employees and how they take action in response to violations of those policies. But the employment laws have stayed the same. Those haven't gone away. So it is a bit of a balancing act that employers need to be aware of. And now I'd like to pass things over to my partner, Fernando Rodriguez-Marin, who will be talking to you about social and governance components of ESG. Thank you.
Hi, my name is Fernando Rodriguez. I'm a partner at the New York office of Bracewell, where I practice project finance, and I'm a member of the ESG group. I was a participant in our first seminar on ESG, which was conducted in June of this year. And as part of our follow-up to the seminar, we decided to question the attendees on what they would like to learn more about after attending our first seminar. One of the areas that we received a lot of comments on was, we'd like to know more about the S and the G on ESG. And to respond to that interest, I thought it would be good to reach out to someone at a international institution that has been leading ESG efforts for decades now. So it is, we've been privileged to have the chance to interview Luiz Gabriel Todt de Azevedo, who is the chief of the ESG group. He's director of that division at IDB Invest, which is the private sector financial institution that is an affiliate of the Inter-American Development Bank, which is a multilateral institution owned by 47 different countries, 23 of which are in Latin America and the Caribbean. So, and as part of the remit of the bank, their financing includes not just providing loans and guarantees, but also structuring funds and investing in equity in some cases. So with that introduction, I hope our audience can see that we're going to have the chance to hear from someone who has a lot of direct experience on these issues in a very broad region where our clients and contacts are certainly doing business. So again, thank you, Gabriel, for being here. I'd like to start the interview just by asking you a bit more about what you do, what your position is at IDB Invest.
Sure, Fernando, and thank you so much for the invite. I'm delighted to be here. I was particularly puzzled when you first approached me, when you mentioned the interest of your group and your clients on the S and G. Because that's what we see. That's what we have seen in the past few years. This whole discussion started with really the E, the environmental issues. But what we see today as the most challenging and the challenging issues and best opportunities, at least in Latin America, Caribbean, are the social issues. And the G part of ESG is still kind of fuzzy to a lot of people. So hopefully we can shed some light today as we talk. Regarding my role at IDB Invest, Fernando explained, I lead the ESG group at IDB Invest. We have a dual role at our bank. The first role is we are trusted to preserve the reputation of the institution and to identify and mitigate non-financial risks in the ESG space, which we know can quickly escalate to financial risks as well. So that's the first role, risk management, ESG risk management, reputational risk management. And the second part of our work, as we have framed it in IDB Invest, is what we call the value addition part. Once you have the risks under control, as a development institution, what can you offer to clients or to investors so that their project go beyond doing no harm, and we can add value to their businesses, and we can add value to the development impact of what they do. So we are about 35 people, fully dedicated to that, many of which have years and years of experience. And we also rely a lot on local expertise in the countries where we work, and also to specialized consulting companies that support our effort on ESG.
Great. Well, I didn't expect any less than that. So, of course, obviously, the bank is very much a supporter of the UN Sustainable Development Goals, and I would like to know more for our audience. What are the activities that the bank is doing to actively promote sustainable development in the region, which includes Latin America and the Caribbean.
Right. Yeah. So we operate in Latin America and the Caribbean, as you said. So everything from, the easy way to put it, from Mexico south, every country. That's where we operate. As you said, we operate, in our case, IDB Invest only with the private sector. Obviously, the IDB group is much broader, and we have our big brother, which is the IDB, working with the governments, the public sector in those countries. Regarding the ODS, the development goals of the UN, I think they provide a common framework that all of us, private sector banks, can use to gauge or to benchmark ourselves vis-a-vis what are we trying to achieve in terms of development or contribution to society or whatsoever. And I think the key is that, and in our case at IDB Invest, we try to correlate everything we do in terms of their contribution to each one of the goals. So if you go into our site today, there is the same graph, the graph of the ODSs with the boxes. Our boxes change in size, trying to show to which goal we are contributing the most during that year or we have in the past. So they provide a common framework, a vision, a goal towards which we can all work for. Now, I think for each institution, again, be a development bank, a private investor, a private bank, a company of any sort, it's important to determine which are my comparative advantages and what matches my mission the best. It's hard to imagine that one institution can equally contribute to each one of the 17 goals. So what is your purpose? And you may be able to contribute more to 2 or 3 or 4, whatever. In our case, currently, we measure our contribution to all of them, but we are operating under the umbrella of what we call our Vision 2025. And the Vision 2025 has 3 medium-term strategic goals. First, reactivating the productive sector in Latin America and the Caribbean post-COVID. Second, social progress. Again, there was a backdrop of social issues with the pandemic. And the third one is good governance in institutions. And we are operating, focusing our work and investment in 5 opportunity areas: regional integration, the digital economy, supports to SME, small and medium enterprise, gender and inclusion, and the 5th one is climate change action. So these are the 5 areas that for the next few years, we are really trying to gauge ourselves against, benchmark ourselves against, and that we hope to be mostly contributing to those set of goals dealing with those benchmarks.
So to be more impactful.
To be more impactful, yeah.
All right. So, as I said in the introduction, the bank has a dual, has multiple areas in which the institution acts, and to broadly divide them. It acts as an investor and as a lender. In this role as a lender, and especially as a project finance lender, it was an early adapter of the Equator Principles and the World Bank principles. Can you just, to our audience, tell them really how important these are? Because in practice, I have seen that in my practice, but maybe you want to just talk about how important those requirements are.
Sure. Very quickly, I will mention, because on the introduction you mentioned that you're in the project finance part of the company. This is our strongest sector, really, project finance. We operate in several sectors: infrastructure, the financial sector, services, corporates, but infrastructure, project financing, when IDB Invest was recreated in 2015, our mandate was to be bold in infrastructure and to take risk in project finance. So we are recreated with that purpose, to be more impactful in that space. And for everything we do, I think, first, you mentioned the Equator Principles. I think the Equator Principles are a benchmark. They're a set of standards that were developed for the financial sector, primarily, that established a minimal benchmark for environmental and social due diligence upon which all of us should follow. And from the Equator Principles, the derivative of the Equator Principles in terms of operation is what we call the IFC Performance Standards, which is the operational phase of the Equator Principles that have been embraced today by 105 financial institutions, public, private institutions, and obviously most of the development banks. So it is at the core of our due diligence and our analysis. We have our own environmental and social sustainability policy. In our case, we have just approved with our board a new one last year. It's a lengthy process that involves consultation with multiple stakeholders, multiple drafting, a lot of support from our lawyers. but it was approved. So we are operating under a new policy framework that was launched in December 2020. And I would be glad to share with all of you, because we have the policy framework and we have the implementation manual, which is like the instructions to implement the policy. And but in our case, the core of our policy are the IFC performance standards, the 8 standards, which are closely correlates to the Equator Principle. So everything we do, every project that IDB invests, be it lending, equity, even technical assistance, when we do advisory, grows through our department. We have to look at everything. And the lenses through which we look at the environmental and social part of it are the IFC performance standards / the Equator Principle. So I think they are the international benchmark. There's no doubt about it. And as I said, today, it grows every year. When I was presenting the policy to our board last year in March, I remember the number was 92. Somebody told me today that 105 financial institutions worldwide have now adopted the IFC performance standards.
Yeah, and I what I understand is that the institution, the companies, especially if you like, militant in its covenant package and requirements to actually put some teeth on those operative principles.
Right.
So just can we then turn to the actual social goals of the bank?
Sure.
Just give us a bit more.
Sure. For us as a development bank operating in Latin America and the Caribbean, it is clearly our main goal to support, to provide, means for advancing the poor and the most vulnerable groups. There's no question about that. This is our goal, to work towards poverty reduction and inclusion, ensuring access to those that are excluded. And when we talk about vulnerable group in Latin America, there are many. There are women, the LGBT plus community, but the indigenous communities, the Afro-descendants, and other groups. So this is really the focus of our goal. We do this through the private sector. So we do not expect our clients necessarily to have very bold CSR policies or anything like this. But what we try to do is, number one, identify clients and or projects to which we can build win-win situations so that we benefit businesses, we benefit companies, but we are also contributing to social advancements, to social equality and empowerment. So this is in a nutshell. The other area that when I mentioned in the introduction that I was puzzled with the question about the S and the G. The other area that we see more and more over the past 5 years, and unfortunately with the pandemic, we have seen a growth of some of these issues, the whole space of human rights violence, which associated with poverty reduction and inclusion continue to be a challenge for us in the development world. We've seen through the pandemic, for instance, in different countries of the region, a growth on the prosecution of social defenders or environmental defenders, or even with those that have worked on curtailing corruption. So unfortunately, we've seen over the past couple of years a growth again on those reactions. And as a development institution, we try to work for a fairer, more just playing field.
And as I think if I hear correctly, you're really both proactive in the sense that you're trying to make people to sort of promote those projects and those companies where those goals can be supported, but also just make sure that you're not engaged in any transaction where there may be any risk associated with that type of behavior.
Right. So basically, when we do our due diligence, first we want to identify the risks and obviously to avoid or mitigate or compensate for those risks, right? So that's the starting point. And then beyond that, what can we bring to the table to our clients, their benefit and to the benefit of communities in addition to risk management? And I always tell my people, and that's important to highlight, do not be afraid of the complex, difficult projects, the project financing, the road through the Andes or the big hydropower. That's our role. Don't think about the project, think about the client. If you choose the right client, if you choose the right person to deal with, and I think speaking to lawyers, you will understand that better than engineers like me. No, the technical part, it's easy. If you have alignment on vision and goals, you can overcome the technical barriers. Now, the other way around, it's more complicated. So I always tell my people, try to focus on who are you working with? Do you know this client? Do they share our vision? Do they want to do the right thing? And we can always overcome the hard part.
And that is actually a segue to the next question, to move into the G, right?
Yeah.
Because you want to know who you're dealing with, and you want to work with companies that are exemplary, or at least certainly not infamous, but exemplary if possible. So in the governance part, which you said is more fuzzy, it is really a bit, as I understand, more in development, right? But of course, you mentioned earlier, corruption is a problem worldwide. We could say the U.S. is free from it, but it is probably more prevalent in some countries in the region. So can you just explain a bit more about that G part?
Yeah, first I want to mention that why is the G there? And the G has been with ESG for at least 20 years, but it's still fuzzy. And what I always know, I make some comparisons, especially when I'm talking to the team, and I say, look, corporate governance is vitamin C. Compliance is aspirin. When you're going to compliance, you already have a problem. So try to work on strengthening the body so that you don't get there, right? And there's ample evidence to show that companies that have good governance, they're more sustainable. Because some of the challenges that we're living today in the world, and we're seeing with the pandemic, and we're seeing with the whole debate on climate change, for instance, they really require tone from the top. They require policies, government, but they require business leadership. They require vision. And I'm not suggesting here that businesses are giving up on their profits, but they have to make choices. And as we move from a world that is defined as shareholder capitalism to a world that we define as stakeholder capitalism, companies are not being measured only by their bottom line return in terms of profit. Their shareholders, their investors, they're also looking at what other indicators can I evaluate you, my management, against, no? And there, I think for us, issues like transparency, ethical behavior, the rights of minority shareholders are critically important to contribute to companies that have a long-term perspective. I know people say, and I think they're right, profit today is definitely a necessary condition to sustainability, but it's not sufficient. You need more than profit. You need profit and something else. And this something else comes with leadership vision. It comes when you elevate the discussion to the boardroom, to the C-suite at the companies. And that's why it's so critical for us. And we have within our team a corporate governance team. I have few lawyers, corporate governance lawyers working for me. The person who leads that group is someone that came from the private sector, from a large, office in São Paulo, Brazil. And that's what we're trying to do. We are trying to build a progressive dialogue with our clients, with their boards, with their CEOs, with their CFOs in terms of internal controls, how to present themselves, on being transparent, on disclosure of information, on the rights of minority shareholders and other points.
And labor issues too.
And labor issues too, how they treat their employees, now how they treat their suppliers. All of these come under the umbrella.
Correct. That's I should say that's when I went to law school in the late 70s and I took my first commercial law course, I never thought that the world would evolve to having ESG as considerations, because I still remember those classes where you just, shareholder profit is paramount, and, pecunia non olet, and things like that people used to say. Anyway, so just I'm conscious of your time. Just wanted to, if you could touch a little bit on the metrics, because these are performance indicators. They call the KPIs.
Right.
So how important are the metrics, and not only the actual metrics, but also external verification?
Verification, sure. No, very quickly, in our case, the metrics, when we talk about the ESG part, it's really part of our policy and manual. So we conducted due diligence in everything we do before, during, and after. Actually, my group, people joke at the institution that we're the only group that actively sees a project from cradle to grave, because we're the first one in and the last ones out. So we have our own metrics, and it's fundamental that each institution develop their own so that they can measure, where they're going. So that in terms of risk management. Then we have another sort of set of metrics on the value addition part. In our case, we call it Delta. It's an acronym for a long name, but it's basically the result of a detailed econometric analysis in terms of benefits and what additionality the project brings. And it normalizes this whole analysis in a number between 0 and 10. And we have self-imposed upon ourselves publicly that it was not a board requirement, it was a management decision that we need to maintain an average of 8 for our portfolio, and that we do not finance anything with a delta below 6. And that is not saying that it's a bad project. It's not a good fit for us. And what we have done to put some teeth, and I know lawyers like teeth, we've announced publicly, and we do, that we disclose the delta we estimate for every project before we approve, during implementation, and after implementation, so that the world knows this is what we are forecasting, this is what you got in return. In terms of verification, we do not require verification. We do our own verification, with the exception of thematic bonds. We do a lot of thematic bonds. We've been very large in the region. I think we are the main supporter of thematic bonds in Latin America and the Caribbean over the past 3 years. And for that, the market, in addition to us, requires a third party. So we use that third party, but we still make the final evaluation. But it's very important. For Category A projects, which is the large, complex infrastructure project, finance projects, we always require an independent environmental and social consultant that provides their opinion to us. And again, we make the final evaluation, but there is an external opinion. So it's always a plus, not required in every project. In some projects, it is required. As an institution, though, we submit ourselves to third-party evaluations, because we also go to the market to get money, right, to self-finance. So in January, we issued a $1 billion sustainable bond, right, to the market. So we finance operations through this bond. And for that, we ask third-party independent evaluations to pass judgment on our ESG practice. And I'm glad to see that this year we scored the highest grade in the market, and we are very well received with our sustainable bonds. We issued a $1 billion sustainable bond here in the US in January, and then we've issued a gender bond in Mexican pesos in March, also very successful. And for those, obviously, we are engaged by external parties.
And you were one of the precursors of green bonds, right?
Of green bonds, yeah.
Which would be the easy early ones. Right?
The early ones, yeah. Now, no, green bonds, I think they tend to grow a lot in Latin America, but we are also talking about sustainable bonds, social bonds, climate bonds, gender bonds. And we are in the process of perhaps issuing our first blue bond, which is related to oceans and water. So,
fantastic. Well, I think with that, I think we've taken enough of your time. Thank you very much for coming.
Thank you so much, Fernando. It's been a pleasure, and all the best to your clients, your colleagues in the firm. And I'm delighted that you're raising the profile of this ESG discussion. Thank you.
Thank you very much.